In order for a motion picture to be made, for example, the chain of rights needs to be, first of all the rights need to be consolidated. A film has got visual elements, it's got performance elements, it's got musical elements and so on, and there are rights attached to each of those elements. They have to be consolidated in order to package the film and then send it down the value chain. And that right of title needs to be consistent throughout. Now, the 25-year reversion right is essentially premised on the idea that on occasion a work increases exponentially in value once it's out in the market. And an artist who might have been involved in the creation of the original can see what he got paid a reasonable pittance for suddenly earning exponentially greater numbers for others. And it just gives an opportunity for them to get back onto the bandwagon and reap in some of the increased value of their work. I'm thinking, so something like, let's say, The Gods Must Be Crazy, for example, was a film. It was a relatively modest film, and it went out into the market. It's still showing to this day in places. And none of the original creators have seen any increased value. So that's what the 25-year reversionary right allows, is an opportunity to renegotiate. It's not an opportunity to close it down or to take it back. It's an opportunity to renegotiate.
Of course. So it's a good thing. It's a good thing. Before we come to Sean, I see Ben, you wanted to come in there.
Yeah, I wanted to say, it's amazing, Sean, we started this conversation during the lunch break, that you are coming here under fire from many other folks who are photographers and creators who have either been captured by those who argue that the bill is terrible and must be thrown in the bin, or are confused, that you're coming and having this engagement. Because this is the way that we're going to find our way forward and we're going to make this thing work. And I get the feeling that as you go through, word by word, the provisions that are worrying you, it's almost like you're starting the next workshop that has to take place the day after the president signs the bills, in which we'll be writing the regulations to go alongside the bills. And I'm afraid we may have to bring Comrade Fubs out of retirement on that day to help us with the writing of the regulations, because this has been a long journey and we're going to need the intellectual, the institutional memory of those who traveled the journey with the bills. But definitely when it comes to the specific issues that you're raising, who owns a work that is commissioned by often a state entity that puts money in, the bill definitely tips the balance slightly more in favor of the creator. It says the default position is no longer that the commissioner just owns it by default. There has to be a negotiation. There can be a negotiation. There should be a negotiation. That's not enough, obviously, because that negotiation could still be held in a climate very hostile to a creator, particularly with small upcoming filmmakers. That's something we always have. I'm sure you face it as photographers as well, that those who are commissioning and buying your works are much more powerful than you as an individual creator, and you need a sort of union or representative structure to hold that negotiation. But I think if we are as engaged as you are, and if Recreate can help as well, we will have to sit down when the regulations are being drafted and say, okay, we want to define what kind of process should take place in order to determine who has ownership when works are commissioned by the National Film and Video Foundation, by the SABC, or by other state entities. There was a very funny meeting with the NFVF once where they said, actually, we've never wanted to own anything. We just found ourselves owning a bunch of stuff because under the law we own it. So we rather welcome this situation where we don't. There's a couple of other provisions. You raised one other one in detail that you went through, So I was going to quickly comment. Oh, the orphan work one. Right, the orphan work one where you're worried what happens if something is an orphan work and then the original owner is found. You know, not enough work had been done to find the original owner. I think, Joan, were you going to say something about that? There's a sense in which the state is supposed to be a custodian rather than an in perpetuity owner of the work once it's orphaned.
Well, I'd hope to remain silent, but
You still have that right, I believe.
indeed, you're quite right, Ben, that the legislation points to the state as being a custodian of the work, and rigorous efforts should take place to find the actual owner of the orphaned work. But in the absence of being able to find this person, the state would continue to hold it as, well, have it as a custodian and receive the royalties. But when such a person is found, when the person is found, or the family, if the person was deceased and that's why the person could not be found, then the funds must be returned to the rightful heir, if I can put it that way. But I'm sure most of you know that not everyone was very happy with that at the time, and among the many reasons which were repeatedly put forward was, I mean, well, we can't even trust the state. Look what it's now doing with the tax money. And you're now saying this. Well, I am of the opinion that given the corruption, commissions and so on, that the state may well be turning around, but for that matter, the private sector too is corrupt. For that matter, many trusts have been found to be highly corrupt, some of them legal ones. So all I can say is currently that is the situation. But what can happen is that in regulation, which remember is secondary legislation, it has the same power. It must just be within the principle of the legislation. But I do think that continued conversation will inform the regulation itself. And those of you who are interested, and I would hope everyone is, would pursue this.
Just the last word, Adrian, your thing of, explaining the reversion as almost a second bite at the cherry to have a look at, has the value of the original work increased, which in the case of fine art is sort of legislated in the bill that a new royalty goes to the fine artist. But in the case of a film production or whatever, I think there would need to be work done in regulations to sort of explain how that's going to happen. And I think the concerns of film producers, I'm not necessarily admitting to be sympathetic to the Motion Picture Association of America, but those film producers who are, sincerely engaging would need to be around the table in order for us to have a conversation. How can regulations govern the process by which that second bite at the cherry takes place in a way that doesn't mean that, a film suddenly falls apart and the revenue streams are in chaos because nobody knows who has what stake?
Okay.
Yeah, I think they put forward a scenario where, for example, they would have to redo the entire soundtrack because some artist is holding them to ransom. Obviously, regulations would need to consider that scenario and provide some kind of remedy.
Yeah, no, thanks. So it seems to me as if the regulation, to a large extent, will help clarify some of the issues. So I want to take that hand, Mr. There. Let's listen to you and then the next one. Thank you.
Thank you. My name is Du Masandi Lembon from SABC. I think if I can reflect to the case that Sean is talking about, I think the resolution will go a long way, especially when you're talking about in terms of images and photography, eventually when it's resolved. It's quite interesting in the sense that if you look at it, what else was he supposed to produce if not the negative? I mean, what does GAP, because it looks like GAP is not disputing the usage that is used so many times and whatever, and the fact that they didn't regulate the usage of it after whatever agreement they had with your managing firm. But at the same time, I'm just trying to, I've heard something that is going to go a long way in terms of the resolution will go a long way, because if you look at it, maybe it will give a standard in terms of, in this area where photography is concerned, when you have to prove ownership, these are the things that you have to put on the table. These are the things that we will want from you. So I think it's, the position by government is quite absurd. I really don't know, maybe someone would give us some idea what else would Sean, what else he had to provide when it comes to that kind of a case. Thank you.
Okay, the next one. The next one.
I believe that it was a part of a delaying tactic because certain bodies knew that the case was going to prescribe. And then trying to get hold of the foundation and to actually get the information from them. The first time I had an email written perfectly, and I was told, no, it needs to be on paper. And the paper one changed 2 words. And since it was changed, if, that was it. And even though that I had the negatives in my hand, and I explained to the people to be, or the people in that time, that, you know, there was no if. I was the photographer. The photographer mainly, 99%, always keeps his negatives. Now, under that auspices of regulation, and that's where, again, that it took so long. So when I went and sat down with CPIC and I explained to them that in the future, let's look at ways right now, and this happened last year, that no other creative would be in the same position. Because if you're giving us the runaround, it takes our time, money, and despondency, and that's the reason why the majority of the artists are despondent and leave their work to the infringer.
Okay.
Thank you.
Thanks, Sean. I think I want to get Basil Dube to comment. He was supposed to be part of the panel, but protocol matters. Actually, he was asked not to be on the panel, but to participate from the floor. But he's here. He didn't let us down. He did come. Basil?
Thanks, Chair. As mentioned, we come from the South African Lawyers for the Creative Arts. And I think I must emphasize to the artists who are here and other media people that the South African Lawyers for the Creative Arts, it's a body that is, it's a human rights body that offers pro bono services, meaning that we offer free legal service. Sean Harris, you must know that. We work with, currently with 16 lawyers that have committed to the pro bono program. So we'll share that as we go. I want to raise 2 or 3 critical issues quickly. One is that I want to deliberate on the issue of the creative sector. I think one of the problems that we're facing in the creative sector, entertainment industries, is that we lobby very effectively, we mobilize effectively, but we do that in the boardroom. That is the problem. I think we must begin to migrate from the boardroom to the streets. I will tell you, if you look at organizations such as Section 27, Right to Know, that is, your gender-based violence movement, their strength lies actually in lobbying with a strong voice. You know, sometimes we end up actually in the boardroom talking to ourselves. So we do not have any effect. That's the first point I want to raise. The second point, I want to respond to Adrian. Adrian, you have raised a very critical point. It is a sad story that Isidingo is being shut down. Now, you can imagine how many of the actors and the whole personnel from technical production will actually be without jobs. And the problem also that we have picked up is that whenever there's a bill to be enacted or to be passed or to be signed off by the president, we sort of suspend activities. Like in our sector, continuously, work must go on. It can't be business as usual. To come and tell us here that the SABC doesn't have money, that is why Isidingo is shutting down, is not enough. We need interventions now. We cannot allow our people to be exploited under the pretext that, no, we're waiting for the president to sign the bill. So we are ready to engage with you, Adrian, to look at the mechanism of intervention. I give you an example. The generation 16 who were fired, all the actors generation, the 16 of them, since they were fired 2 years or so ago, the majority of them are still unemployed. It's only those with big names who have jobs now. You understand? So we have to allow it again with the Isidingo and others. And there's also no guarantee that generation will make it for the next 2 years. Now, with Isidingo, the broadcaster and their friends are obviously flighting Isidingo outside South Africa. Why are the performers not having access to royalties? This is something that we need to look at. These are practical examples. We're not talking theory. So there's a need to strengthen our unity, to work together, and forget this thing of, individualism, that we can do things on our own. It's not taking us. The comrade from SATU will tell you that if you don't go to the street, the president will not hear you. Thank you.
Okay, thank you very much. We are eating into the next panel's time, but I think you're raising poignant points. But I think, Adrian, if I hear Basil very well, the point you're making is that it's not an issue of sitting or being canned. It's an issue of when it's been canned, others will be milking it in other territories through your royalties, and the actors will be left dry. So I think.
Yeah, I don't know if that was a question addressed to me, but I think it's the point that I made in my presentation, which you've just reiterated. Thank you.
Yeah, and I want us to wrap up, but Joan Phelps, I think, I know that you're refiring, you're not retiring, and I'm glad that you're now in the highest office in the land, and you are assisting in there. And I've been following minutes of your committee when you were chairing. The issue of education is actually less, Basil, is less about going to the streets, but about education. This event was widely circulated to the creative industries. But you can count, where are they? And I always say, creatives have got one disease. They are fast to cry foul. And creatives, naturally, we want to create. But I had to learn the balance of creating, but also understanding that after I've created, what happens to my work? And this is where there is the missing link. And I'm glad that you mentioned all the time in the committee to say, DTI, CIPC, you need to educate artists after these bills have been signed. But the problem is that when you speak to them, they will tell you how much 0-month budget they have for this. So we need to find other creative ways. So with that, I want to wrap up and say thank you very much, guys. Why I had to eat into another time is that I'm so passionate about this. I'm a creator myself, so and also we needed really to talk about this. And the lady there, I am reminded, the Marrakesh. I know you asked a question about Marrakesh. That has been signed. We have assented to that Marrakesh. I think Mr. Titlek mentioned 2013, if I'm not mistaken. But yeah, we have. So and that Marrakesh, for it to be effective, we need. We haven't. Oh, we haven't. Sorry. Okay. Sorry. My apologies. I'm just saying that for Marrakesh to be able to be effective, we need this bill. Just like the performance bill, for it to be very effective. And people are talking about delinking. Delinking is not going to work because it's not just separating the two bills. It's a process. But with that said, and excuse my derailing there, thank you very much. And let's give them a round of applause. We ready for the next panel?
Thank you all for staying to the real technical stuff now. We have a team of lawyers and law professors here to discuss, the legal complexities of where we can go from here. So my name is Sean Flynn. I'm the director of the program on information justice and intellectual property at American University in Washington, D.C. And I've been working on and off on projects here in South Africa since I first came here in 1999. And I think I probably met Andrew and Jonathan Klaaren maybe that year. And Peter Jaszi and I have been working with especially documentary filmmakers since about 2007. And we're, American University has been, part of this project as kind of technical advisors to various groups as part of a project that we call the Global Expert Network on Copyright User Rights. And this is a network that was founded in 2011 with the purpose of giving advice about some of the positive aspects of U.S. law, particularly its fair use regime, that are not commonly exported by the kind of official machinery of government policy, and nor are they exported, as Jonathan Band was talking about earlier, by the kind of U.S. entertainment industry. But it is very much a key part of our system, and it's a system that's being emulated in many other countries. And so we formed this network with experts from about 30 different countries to provide advice where requested on the technicalities of fair use type regimes and other mechanisms of limitations and exceptions and their values. So that's kind of why we're here. And we have this panel of legal experts. So I mentioned Jonathan Klaaren from the University of Witwatersrand, sitting to my right, and Enyinna Nwauche from the University of Fort Hare. Peter Jaszi I've introduced, and Andrew Rens, who's a roving legal expert these days, I suppose, and a consultant with our project and a member of the User Rights Network as well. And so I want to very much encourage you to kind of think of some of your questions as we go, because I would like this to be, a panel that has some engagement. And I'll start by kind of launching some questions to our panelists and inviting us all to jump in at various moments. But I want to start with that first question that the last panel was really starting to get into, which is how and whether we can help define some of the issues in the bill that have maybe been pointed out or sometimes criticized as maybe being vague or being new and not knowing how to work them, and whether and how those issues could be clarified further in regulations. And so I want to invite Jonathan maybe to first come in and tell us a little bit about what is your perception of the South African law on these issues. What can the agency do, and what boundaries are there on what they may not be able to do things like define ambiguous terms and lead more guidance into various aspects of the statute that may be vague, ambiguous, etc.
Okay, so I'll do some of that. So I teach at the law school here and also work at Wiser, which is a research institute. And I think the interesting part of that and the relevance of that is the Wiser Institute is an interdisciplinary research institute. So it works with literary studies people as well as legal and social scientists, legal studies and social scientist people. So I think this is, so this area, this effort, the Copyright Amendment Bill, is one that I come to a little bit from that background. From the background of public law, thinking about constitutional and administrative, I think what I want to say here are three things, and it's partly responsive to what Sean has said. We know from the sessions this morning that where the bill is at, in the sense of, I think we had several people saying, please, Mr. President, sign that bill, right? So, and we were being told that, which is correct, that in terms of the legal position at the moment, the veto, or what the question is before the president, is about the constitutionality, not about the policy of the bill. But clearly, around the bill, there are many questions of policy or politics and interpretation. And I think it's a challenge to us, both as the kind of legal technicians here, but also as the consumers, users, citizens in this effort, to both separate out that kind of technical legal let's call it constitutional for now, level, but also the more social and practical level. Because the first large point that I'd like to make is that while it is absolutely clear, as our former MP and former chair, Ms. Fubbs, spoke and said, that technically and legally, regulations are subordinate legislation. And she emphasized the part about legislation. Meaning, you can go to jail just as easily for a violation of regulations as you can for the primary legislation. Meaning that legal rights and legal processes can be just as much created in the regulations as they can be in the primary legislation. Nonetheless, from a sort of broader point of view, the regulations are really about the implementation of that law. So the law is sitting there and it's got a whole bunch of rules, and as you heard from, for instance, I think it's Sean Field, am I right? Unless you've got the money to bring the lawyers, you may not be able to actually bring those legal rules into play, especially when there's entrenched interests or a quite patterned industry, etc. around. So the level of the implementation at the regulations is really, it's often the more significant in that sense level. And it is really a separate level. So the first point that I want to make is the difference between the law and the regulations. That said, there is this legal doctrine which is followed by good legal technicians, such as are on this panel, right? Where the regulations must not go beyond the scope of the law. So they can't go beyond the bounds of the law. So I think part of what we're about in this Indaba, and it's raised by Sean's opening, is to what extent can regulations help or even solve issues or problems that may be there with the bill? And to one extent, and almost even the answer that I would expect sort of my at least beginning year law students to give is they can't. Because the regulations must work within the parameters of the bill. They can't claim any power that isn't actually there. And if they do, then they can actually be struck down. So it's a bit of a paradox, this one. But trying to think it through in the context of this very complicated, or at least confusing, place where we are in the legislative passage and enactment and implementation of this bill, the Copyright Amendment Bill, I thought that the last 2 points I would make would be to offer 2 propositions on 2 areas of controversy in the bill. So as we've heard here, fair use is one area of controversy. Another area of controversy, whether it's constitutional, there are sort of, you can take constitutional slices at it, you could take policy slices at it, etc. Another area is the, what we were just talking about, the author royalty rights. And I think actually that regulations may be able to assist in both of those areas, but in different ways. So if you take the concept of fair use, it is to some extent spelled out. There's something there in the bill about it, right? There's some sense of what domains it can be used in. There's a little bit of factors, etc. But as I think the earlier panel was pointing out, there's room for much more guidance and clarity. So I think that's one place where regulations can really help in clarification as to what, and giving guidance on what fair use might actually be. And that could be very helpful in, for instance, making it clear and also making it a matter of law that, for instance, certain uses which maybe someone might think would be a fair use, let's use the example of plagiarism. And I use that in part because that has actually entered the debate here. Some have claimed that a fair use would be a plagiaristic use. And that's, an important use to me, or it's an important concept because coming from legal education, we tell our students not to plagiarize. And for the most part, they don't. Not entirely. That's why you have enforcement. So I think one thing there is that regulations it might be, as this legal opinion that Jonathan Berger was talking about at times using the point, it might be overcautious to put this in the regulations, but you could even say, and plagiarism is not fair use. Something like that. So that would actually clarify and I think maybe help. And certainly in the sense of if you thought that, say, plagiarism was within the bounds of the law and that made it unconstitutional, then it would be clarifying the point that it is not unconstitutional. So that might be one way. The other way, if I can just finish with that, is on the author's rights, reversionary rights, or royalty reversionary rights. Okay. I think here, if we go back to my first point about how regulations actually implement a law and in fact become the operative law, regulations can actually do more than clarify the law. They can actually add a structure. They can supplement the law. So they can't go, again, they can't do that beyond the authority of the law, and they can't do that contrary to the purposes of the law. But if, for instance, one is setting up a process whereby agreements are to be negotiated and made between the, if we call it the manufacturer of the copyright and the owner, or the artist and the owner in that sense, that's the sort of process or institution that actually can be created affirmatively. It's something more than clarification because it's actually a proactive adding on. But it is something that would give some substance to, in that case, the mechanism that the bill is authorizing to be made. And I think that's a second way in which regulations can actually assist in addressing some of these very controversial aspects. If I can just, for 10 seconds, mention, since we are being technical here, that there's a set of regulations that are almost sort of regulations within regulations, in a sense, relating to those provisions that I've just spoken about with respect to the Act. Ms. Fubbs, I'd be interested if you think that's an accurate way of describing it, but it's effectively, as has already been alluded to in the earlier panel, that Parliament, in enacting the law, felt that there were, they wanted certain sets of regulations and an impact assessment around this controversial area of authors' reversionary rights to actually be set up and brought as a draft in front of Parliament and then actually enacted and going forward. So, and that is maybe part of that institution as well. It's basically a political arrangement that is certainly within the, I think, actually, the power of Parliament to give. It's done at the level of regulations. Well, it's done it will be implemented at the level of regulations. And I think it will help the bill in terms of the resolving the controversy that's there. So, done.
Yeah, any other questions from the panel on this, topic or comments? Peter, yeah.
Yes. So, more a comment than a question. That was extremely enlightening, and it gave rise to a few thoughts on my part. One is really a further development of what you said, and the other thing sort of a cautionary. The further development is that another thing that regulations frequently can do is to define terms and concepts which, for whatever reason, are not defined or fully defined in legislation. And in the case of this bill, that might be quite helpful. So, for instance, one of the somewhat controversial provisions is the provision of Section 12D that contemplates a set of circumstances in which educational institutions could make complete copies of textbooks for distribution to students. And it includes one provision for out-of-print textbooks and another provision for textbooks that cannot be obtained at a price reasonably related to that, normally charged in South Africa for comparable works. Now, neither of those concepts, the concept of a book being out of print or the concept of reasonable price in relation to normal charges, is entirely self-defining. There is a real question in the publishing industry about what should be considered out of print in the age of digital licensing and publishing on demand. And there are certainly questions about how one would relate the price charged with, for one textbook, to the general pricing structure for other textbooks. Those are both issues that could be successfully addressed in regulations of a definitional character. And that strikes me as a modest but very useful additional way in which the power of regulation, which is conferred so generally on the minister in the provisions of the 78 Act, which will remain unchanged when the Revision Act becomes, or the revision bill becomes law, could be utilized. So that's my positive contribution. My cautionary goes to your discussion of plagiarism, not in particular, but as a general matter. And that is, as I think Jonathan Band made very clear this morning, and as I might or might not say more about myself in a little while, one of the things that you are going to get with the new fair use provisions in this law that you haven't had before is a degree of flexibility and forward adaptability that fair dealing provisions, for all of their benefits and for all of their close relationship in concept to fair use, have not had, because fair dealing provisions, as we heard this morning, are by definition fixed on certain subject matter. They aren't well designed to adapt to changes in culture or economics or technology. Fair use is. And so I would be, even if it were within the regulatory authority of the ministry to make regulations about fair use that categorically excluded certain practices, I would be extremely cautious about doing so, because I think you can live to regret that kind of an exclusion, whether it is in primary or secondary legislation. By contrast, I think there would be a great deal to be done positively by including in regulations relating to the 12A fair use provisions positive examples of ways in which, in the views of the regulators, this doctrine can and should be employed. That would have the advantage of adding additional clarity, which we know is desirable, and it would also have the advantage of jump-starting the process of implementing fair use in the South African context. One way of doing that, as John Ben pointed out this morning, being to temporarily borrow a few leading precedents from other jurisdictions. But another way to get started to move forward quickly, making a doctrine like that your own, would be through regulations that offer positive examples of how this doctrine might be employed.
Great, so thank you. So I'd like to shift to another topic. Before I do, just kind of, put the bookmark on that one to the extent that, this is a place where a lot of questions could potentially be worked out. Some of those I think we've heard today. I've heard, what's the definition of a performer, for an instance? Does it include an extra, or does it have to be kind of what Adrian was called kind of a mainline performer? How does the reversion work? Can that be used to actually hold up the future commercialization of the work, or could that concept be restricted or defined in some way, and can that be done through regulations? And there's a whole host of other what I would call kind of legitimate issues of clarification that exist in the Act, and I think there's a question here, and I invite the audience to throw them at our panel if they wish, on whether some of these real legitimate kind of issues in the bill of how to interpret, implement it, can be addressed through regulation. And then because of that, does that kind of lower the temperature on the constitutional complaints? If there's something that could be addressed through a regulatory process, does that relieve some of the anxiety and desire to kind of call these things constitutional problems? But let me shift now to another class of constitutional problems that have been raised. We've been speaking a little bit about, but they sound largely in the concept of property. So deprivations of property, expropriations of property, or sometimes conflicts between the provisions, especially the limitations provisions, and other rights. So I know that in this country the right to dignity has been read to include something like a choice of work, and each of those kind of implicates part of the Bill of Rights that could, if the trigger was met, throw the analysis into kind of a limitations clause analysis. So let me ask Enyinna to start and take us through a little bit of that kind of property analysis. How would one look at, be it fair use, or even the royalty clauses, or another ones that kind of pop up and people say, well, that expropriates my contract, or that expropriates my property, or deprives me of property. Maybe giving us a little bit of sense of what are these terms, what's the difference between expropriation and deprivation, and kind of how would you walk through, one of these analysis under the terms of the Constitution?
Thank you, Chair. One of the major allegations against the CAB is that it constitutes deprivation in terms of Section 25 of the Constitution. Section 25 provides that no one may be deprived of a property in terms of a law of general application, and no law may permit an arbitrary deprivation of property. So deprivation is understandable, but it shouldn't be arbitrary. However, deprivation is a technical term. It's simply not just the taking away of property. It relates to the police power of a state to regulate property, the use, enjoyment of property for the public interest. Its counterpart is expropriation, but both reflect the powers of the state to regulate property for the public interest. For deprivation, which is very appropriate in the discussions about the Copyright Amendment Bill, we are looking at the interference with property rights through a legislation. In the First National Bank case, the Constitutional Court set out a scheme for understanding whether deprivation has taken place or not. The first question is to ask whether the property amounts to property, and there is, again, some controversy as to whether copyright is constitutional property. It's not settled, even though some of us think it is. The next question is whether there is a deprivation, and the third question is whether that deprivation is arbitrary. And the fourth is to move beyond a finding that it is arbitrary, to ask whether it is justified under the Section 36 analysis. And if that is answered to be in the positive, then to see whether the interference amounts to expropriation for the purposes of Section 25(2), and then whether the deprivation complies with the requirements of Section 25(2), and whether further it is justified under Section 36. So for our purposes, the allegation really, or the complaint against the certain part, the fair use clauses in the Copyright Amendment Bill, is that it's arbitrary. When the Constitutional Court set out the scheme in the First National Bank, it set out also a principle of sufficient purpose or sufficient reason. And any interference that does not meet that threshold of sufficient reason or sufficient purpose will be held to be arbitrary. The Constitutional Court set out two broad ends of spectrum, or two ends of a spectrum of analysis. For some interference, only a thin rational review, a relationship between the means and end, was necessary. So the threshold will be low. And for other interferences, it would be a thick reasonableness inquiry in which the threshold would be high. So for example, if one were to allege that the Copyright Amendment Bill should be analyzed on the basis of a reasonableness inquiry, the threshold would be high to be met, to be able to say that the Copyright Amendment Bill, the fair use provisions, have made sufficient reason. But interestingly, after the First National Bank, South African courts have changed focus, as it were, moving from this wide, broad test in the First National Bank case to a simple test of significant infringement. In a number of cases, what has come out now is that unless there is a significant interference with property, there is no arbitrariness. And so the question is whether the fair use provisions significantly interfere with the copyright owner's right. And if you look at the many cases, especially one of the recent ones, which is the South African diamond producers, what the courts seem to imply in the peculiar nature of the Copyright Amendment Bill is that there is no right for any copyright owner or for any property owner to indicate that there must be a significant or a particular value that he or she would earn from the work he or she is doing. So before the Act, for example, the Copyright Amendment Bill, given the jurisprudence that has come out, copyright owners would not be able to say, well, our value has been diminished. We're going to earn less because of the amendment. And the reason why I think that the courts have proceeded on this way is to say that the market is inherently regulated. And also, as been pointed out this morning, there is no indication that because of the Copyright Amendment Bill, because of the fair use clause, that copyright owners would lose the value. There is every possibility that the market is such that they could also benefit, as it were. Now, the challenge of deprivation is that we often lose sight of the fact that it is in the public interest, and that regulating property in the public interest involves some deprivation, and that the peculiar property involved, in this case the nature of copyright, is crucial in determining whether there is arbitrariness. So for many other properties, licenses, land, there may be similarities, but for copyright, which has an inbuilt balance, that ought to be taken into consideration in determining whether there's arbitrariness. So for example, some other properties may be satisfied by just looking at the effect of the interference on the property owner. But for copyright, for which there is an inbuilt balance between the public and the private interest, that ought to be part of the questions of arbitrariness. In other words, since copyright requires a balance between the public and the private interest, that public interest, which ventilates other human rights is part of the determination of whether there is an arbitrariness. So if the fair use provisions that are in the CAB ventilate many rights, it stands to reason that you cannot consider arbitrariness unless you consider the other rights which the public interest ventilates in the fair use. So looking at that holistically, you would see that if you combine a Section 36 analysis with the questions of impact on the property owners, the answer would be that the fair use provisions do not deprive copyright owners of their property. So the allegation that the fair use provisions violate Section 25(1) of the copyright of the Constitution would not really hold water. There is certainly some deprivation, but if the power of the state is to regulate the use and enjoyment for the public interest, it stands to reason that those interferences come in the nature of property. No one can argue, it hasn't been argued, that the Copyright Act 1978 deprived copyright owners of their property. The argument, of course, would go that the interference was limited. But if you think about the nature of intellectual property rights and copyright, anybody who owns a copyright would know that concomitant with the rights to extract value is also a right to cater for interests that are public goods, that are for the society. So it wouldn't be strange if there is a redefinition of that balance. And as I was speaking this morning to somebody, there is just nothing in the Constitution that says in Section 25 that the private interest of a property owner is superior to the public interest. That balance, one could argue, should be equal, and that the legislations and interpretations that we give to them is always a calibration of that balance. Sometimes the interests of the property owner is more than the public interest, and so the legal system has to find a way to rebalance that. And this is what the CAB, the fair use provisions, do in the CAB. And the fact that you have the fair use provisions does not always mean that in this interpretation that it will always be in the favor of those who seek fair use. That is important to stress, because the Constitutional Property Clause also protects the rights of the copyright owner. It only gives us a guide in evaluation, in trying to see whose interests will be favored in particular circumstances and situations, so that there is nothing to say that the fact that the fair use clause provides guides means that property will be taken away or value will be taken away from the interests of the copyright owner. To end, in a very recent case, which is Jordan and the city of Shawande Metropolitan Authority, retired Justice Cameron is giving us an indication of how it is important to ensure that in finding arbitrariness, you take the desire or objective of promoting the Bill of Rights into consideration. And that inspiration is to say that you cannot determine arbitrariness alone. You must seek to promote the Bill of Rights in finding whether there's arbitrariness. So in the manner in which the question of the hangover of municipal debts on property that is bought by a new owner was resolved by the court, the inspiration that comes from it is that we must seek all reasonable interpretation to promote the Bill of Rights and the different Bill of Rights that are part of the public interest that copyright seeks to promote. I think that those point to the direction that South African courts will look favorably on the fact that the fair use provisions will survive constitutional scrutiny and find that they certainly will be constitutional. The experience of our American friends and who have shown the way in which fair use is interpreted has shown that it is a landscape that is changing in many aspects. Out of the 280 fair use cases that have been decided in American courts, anybody who does a survey will find that there are ups and downs between copyright owners and the public. And that's the message that we should be putting out, that it is not entirely for those who we call the users who will benefit. Even the creators will benefit, because once you look at those contextual factors, you will see that it could go either way. But the possibility exists, and it is the ventilation of those rights, the interests that have been graphically laid out today, that these provisions are important. And I find it difficult to imagine that the South African court will say that the fair use is unconstitutional because it deprives copyright owners of their property.
Great. Does anyone want to pop in on that subject?
Would like to very
Yeah, go ahead.
Thank you for that really wonderful exposition, and especially for the clearer explanation of how the principle of interest balancing is, in a sense, built into the idea of copyright property, which makes it different in some ways from other kinds of properties. And thank you also for mentioning the U.S. experience. Let me just say a few more things about that experience to add to my colleagues' remarks and to John's this morning, and perhaps to help further to put some of these constitutional concerns about fair use to rest. The first thing I want to say is that although the wording of the provisions of proposed Section 12A in South Africa is somewhat different from the wording of Section 107 in the U.S. Copyright Act, they are structurally very similar provisions, and after some study, I am convinced that they are functionally identical. That what the copyright bill here has done is to unpack and the language of the U.S. law and put it back together again in a somewhat more rational and easily understood framework. So I think that it's strong. There's a strong likelihood that some of the experience we've had in the U.S., and in particular the experience we've had in the last 25 years in the U.S., since the Supreme Court of the U.S. got interested in the question, and since there's been a certain amount of an uptick in significant fair use decisions, I think it's likely that some of that experience may have bearing on the questions that you're facing here. So the first thing, and again, I think I'm restating propositions that are either obvious or have already been stated better than I am going to do so, but I'll do it anyway. There have been a lot of beneficiaries where fair use is concerned. Individual artists, filmmakers, writers, photographers, scholars, teachers, librarians, students, and of course, businesses, old and new, big and small, including, but by no means limited to, the major creative industries as we think about them: movies, software, games, recording, technology. Some of them, I think, are very self-consciously taking advantage of fair use. Some of them are taking advantage of fair use, even though they may not always know that that's what they're doing. But everybody does it. It is uniform and universal. No one who does any kind of creative work or even other kinds of brain work in the U.S. can avoid benefiting from fair use. And it's a win-win doctrine in the sense that it's clearly created far more value in the information economy and in the creative economy than it has in any sense extinguished. First point. Second point goes with the first point, and that is, nevertheless, every stakeholder in the system has complaints about fair use. Some say it goes a bit too far. And that, of course, then they're talking about how others use it, or that it doesn't go far enough. They're talking then about how they use it themselves. But that kind of policy debate is healthy. and it gets worked out in discussion and in the process of promulgating guidelines for fair use, which is something I've been involved in for the last 15 years or so, and even, yes, even occasionally in litigation. But, as I'll say in a minute, not so often. So, many winners, and this is the point I want to make as clearly as I possibly can. Absolutely no documented big losers. No firm has ever been put out of business by someone else's exercise of fair use. Firms have gone out of business, but it hasn't been for that reason. And at least to my knowledge, no individual has ever been discouraged from pursuing a creative career or a career in teaching or a career in librarianship by the state of the law of fair use, either because they thought there was too much of it or because they thought there was too little of it. It's simply part of the background condition around which people make their decisions about what to do, just as is the fact that you earn more doing some kinds of jobs than you earn doing other kinds of jobs. So I find, and I say this is a very presumptuous thing for me to say, as a visitor, I find the argument that there is a constitutional infirmity with fair use because it may interfere with the choice of trade or profession difficult to square with U.S. experience. And I need to say that. Finally, I want to say that, and this is partly a constitutional, and I think partly a more general anxiety, partly a constitutional question, and as I've heard it articulated, partly a more sort of policy-based or generalized anxiety about fair use. It's turned out, and this has been particularly true, as I say, over the last 25 years in the U.S., that it's actually highly predictable. Anyone who is experienced in a particular creative field, or any lawyer who's done any amount of this work, can predict with high accuracy 95% of the time how any given fair use dispute will come out if it is taken to the test of litigation. And perhaps for that reason, there hasn't been any meaningful increase in litigation over the time during which, in fact, more and more people and firms have been taking advantage of their fair use rights. It hasn't been an engine generating vast amounts of litigation, nor is there any evidence, and this is a point that I want to stress because it is a part of your discourse here, and again, I can't answer for your circumstances, but I can speak categorically about the situation in the United States, nor is there any evidence of abuse of the fair use doctrine by pirates, by those who don't have any colorable basis on which to assert that they are fair users. The notion that and I understand the anxiety strongly, and I hope sympathetically, but there is simply no evidentiary basis for the notion that bad actors are going to throw a fair use defense into the mix as a part of their efforts to prolong litigation or avoid liability. And if they did, it wouldn't work because it would be washed out at the earliest stages of litigation. So it is a real fear, and I acknowledge it as that, but as far as the U.S. is concerned, it has no basis in evidence. And I will stop there.
I'm going to make you start again, actually, because
I thought it was over.
Well, to add to this analysis, it leads into the other complaint that's been made about the bill, which is that various of its limitations and exceptions are alleged to violate the three-step test. So this is the test in the originally in Berne, but included in the World Trade Organization agreements and the TRIPS, Trade-Related Intellectual Property Rights Agreement, Article 13, which states certain limitations on limitations and exceptions. And we had a little bit of a discussion this morning about whether and how international law comes to play. And it seems at minimum within Article 39 of the Constitution on the interpretation of the Bill of Rights, it says when interpreting the Bill of Rights, which would include, for instance, the property clause, it would include, for instance, the dignity clause where a right to choose one's profession has been read in. It says a court, tribunal, or forum when interpreting the Bill of Rights must consider international law. So it's not a hard obligation to follow necessarily, but it seems that it would enter the calculus in some means. And so does the three-step test kind of change or alter anything you've said? And I wonder if, moving off the fair use clause specifically and maybe moving into, for instance, the education clause, where some of the big complaints have arisen there, the targets seem to be the provision that allows the creation of course packs, for instance, or the other provision you mentioned, which allows the copying of entire works if those works are out of print or excessively priced. How might one analyze that under the three-step test?
Okay, thank you. And I will, let me do exactly that, although the one thing I can't entirely do, I can't quite give up on fair use because it's part of the overall story. So I will include it, but I will try to put the emphasis elsewhere. So I want to make, I think there are 5 of them, 5 general points about the three-step test, and I'm going to make all of them subject to the caution that what I heard this morning suggests to me that the relevance of the three-step test in the choice facing the president now is real but limited. So I don't want to overstate the importance of the three-step test as a factor in South African decision-making at this moment. But it's still good to understand it and good to understand what it is, where it comes from, how it works, and why, at least in my opinion, it doesn't represent a significant impediment to the enactment, the constitutional enactment of any of the provisions in the bill. So the very first thing to understand about the three-step test, and I'll say in a moment what the 3 steps are, but even before I do, I want to throw in this little bit of history, is that it began its life in 1967 or thereabouts as a provision of the Berne Convention for the Protection of Literary and Artistic Works, strictly as an enabling provision, as a provision that was designed to help clarify and even clarify what member states, parties to the Berne Convention, could do to create public interest exceptions to copyright law. It was very, very much conceived of and formulated originally as a positive statement towards state legislatures, national legislatures, to say these are things you can do. Now, it's changed a bit in some of the later manifestations that you describe, and it is now couched in Article 13 of the TRIPS agreement, for example, as a restriction on national legislation. But I think its original DNA remains important because, in effect, it is still an enabling provision. It still says if you legislate within these broadly stated metes and bounds, you can do a lot to adjust, to mitigate, to achieve the kind of balance that my colleague was talking about a few minutes ago. So even though the label has changed to designate the three-step test as a restriction, as you formulated it, I think it's still important to consider it as both a restriction and an enabling provision. What are the three steps? The three steps are tests that say that a state can make an exception to copyright law when it applies in special cases, when it doesn't interfere with the normal exploitation, normal is in the formulation, of the work in question, and when it doesn't create unreasonable prejudice to the legitimate interests of, and then different formulations vary. Some of them say author, some of them they say rights holder, but in effect, the proprietor of the rights in question. Special case, it has to be applicable to special cases. It should not interfere with normal exploitation, and it shouldn't create unreasonable prejudice. Three criteria. Now, the first thing we have to ask about those three criteria is how they interoperate, what relationship they have to one another. There is a widely mistaken, but I think easily falsified view of the three-step test that says it's a checklist. You've got to check each point. And if you don't check each box, then it doesn't apply. The proposed exception is prohibited, etc. But the best analysis, the best academic understanding of the three-step test is to the contrary. And the best historical exposition of the three-step test likewise treats it as a holistic standard rather than a series of boxes in a checklist. In other words, a little more of one could mean that you could do with a little less of the other. There has to be some showing on in defense of any proposed or actual national law exception with respect to each of these considerations, but they are interdependent rather than independent. And that's extremely important, especially since the last two, the one having about normal exploitation and the one about unreasonable prejudice, actually overlap each other profoundly in practice. It's my next point. Here comes the next important point, and that is that all of those things, those key terms in the three-step test, the cases have to be special, the exploitation have to be normal, the prejudice has to be unreasonable. Those are all normative, value-based considerations. None of them are objective. None of them can be assessed objectively. All of them relate inevitably to the situation and circumstances of the country in which the exception, whatever it may be, is enacted. So what constitutes a three-step test acceptable exception for the most developed countries may not be the same exactly as what constitutes such a three-step test compliant exception for less developed countries. And that's enormously important, because if it were otherwise, then in effect, the three-step test would become a kind of a straitjacket, and if not a kind of instrument of recolonialization. And that's another important point. Maybe here's the last general point I want to make before I talk about more specifics. And that is, there's almost no law about the meaning of the three-step test. There is really good scholarship. Smart people have thought about it and have developed the propositions that I was reciting earlier, which are far from original to me. But as far as courts or other solid, final interpreters of the law are concerned, there's almost nothing. There's a little Swiss case over here that doesn't make a whole lot of sense, and there's another German case over there. But it's a tissue. It's almost nothing in terms of authority. And that means, and I was so struck by Justice Yakub's formulation this morning, that I think it becomes very hard to say that the exceptions that are contemplated in the amendment bill couldn't be approved while upholding international law. In a situation where the details and specifics of international law have received almost no specific articulation, despite the fact that the system has had 60 years to do it, I think it's very hard to say that a plausible, well-justified implementation of exceptions in South Africa could fail to withhold or fail to uphold international law. Now, there's one possible exception to the generalization that I've just offered. Too often, I would say, writers who are attempting to deploy the three-step test as a explanation of why some actual or proposed exception isn't compliant, point to a decision of a first-level panel in the World Trade Organization in the year 2000, 20 years ago, give or take, involving a challenged provision of U.S. law, which was perhaps the most egregiously obvious example of overreach in that you could possibly think of. Had nothing to do with fair use. It had to do with a provision that basically said, under a wide array of circumstances, music copyright owners can't collect any royalties when their music is played in public in business settings. It was and is, because despite the fact that the U.S. lost the case, it hasn't actually changed the law. It was and is an outrageous provision of U.S. law. And it was, if anything was ever going to fail to pass a three-step test analysis, that was it. The U.S., having lost the decision, having determined that it wasn't going to comply, also decided that it wasn't going to appeal the decision either. So there's no appellate counterpart to this first-level decision, even from the dispute settlement body of the WTO. It's a terrible decision. It's contrary to the best scholarship. Almost all of it is dictum. It was never reviewed on appeal, as I've already said. And of course, it's a WTO panel decision. It isn't precedential in the WTO, let alone for any other purpose. So sometimes this 110.5 decision gets sort of trotted out, and I would pay as little attention as possible to those invocations, because it really is a red herring. Now, let me say something about what a good application of the three-step test to some of the provisions in the South African bill would look like. And here I apologize, but I am going to start with fair use. Fair use, of course, is applicable in special cases and in special cases only. Those cases which have been deemed to represent the relatively few situations out of many in which use without compensation or permission is allowed. So that's no problem. As we have already heard today, the South African fair use provision, like its counterpart U.S. law, absolutely bars substitutional uses. if I go into your market or even into a market that you haven't yet entered and try to sell my product in a way that blocks out yours, that's not, that, of course that compromises normal exploitation. U.S. fair use doesn't allow for that, and the South African version of fair use doesn't allow for that. Finally, as I've said already, in any three-step analysis, the public needs to be addressed always have to be weighed against the private proprietary interests. And that balance seems to be so clear in the way it's been struck as to address the third prong of the test more than adequately. Now, let me talk about the provision relating to educational reprinting that Sean mentioned earlier, that I discussed in one of my earlier interventions. I think that's an even simpler three-step test analysis. That provision applies only in specially delineated cases of market failure, where meaningful exploitation of a work by or on behalf of its copyright owners has effectively ceased in the South African marketplace. So in that situation, the rights holders have no legitimate expectations of economic return from that market. Moreover, as we've heard already, all the publishers would have to do is to change their marketing practice and either license or begin to charge, excuse me, a market price that was reasonable in order to avoid the application of that exception. So I think whether we're talking about fair use or whether we're talking about the education exceptions, the three-step test, to the limited extent that it is relevant to a copyright, to a constitutional analysis, is fully and satisfactorily met by the careful and public interested drafting that informed the new bill.
Andrew, waking you up at the end. But so let me turn from here to another kind of more practical issue that I've heard surrounding the bill, which is that what the president should do from here is either send back just the controversial parts or send back both bills under a tagging theory and then separate out the things that everybody agrees with, the rights extensions, and then keep the limitations and exceptions for kind of later action, or only pass the performers bill and keep the copyright amendment bill for later action. This kind of idea that you can delink either these two bills or the rights from the exceptions in some way. And this was obviously an argument that was actually made in the bill drafting process, but we hear this kind of popping up again as a action for the president to take from here. Thoughts on that criteria?
As we heard this morning as we heard this morning from our constitutional experts, the president can only send any legislation back if there's a constitutional concern. And so I'll talk first about trying to send perhaps the constitutional amendment bill back without trying to send the performance protection amendment bill, and then seeing if, well, this would create a peculiar situation because the performance protection bill, as we already heard from Adrian, is so entangled with the copyright amendment bill that to put it in force would be to have this legislation that can't be enforced and in fact in many respects is simply deficient because it doesn't have definitions. So could but the performance protection bill can't be sent back together with the copyright amendment bill, even if there's a constitutional issue, unless that constitutional issue applies also to the performance protection amendment bill. You can't send, Section 79 doesn't say, And if there's another piece of legislation which is dependent on something which you have a constitutional problem with, you can send that back too. It doesn't say that. The president simply doesn't have that power in the Constitution. So you'd have to come up with a constitutional reason to send both back. If both are back, the claim I've heard is that you could fast track one. Now, quite who's going to undertake to fast track one piece of legislation through Parliament, I'm not sure, but I think that nobody actually has the power. Once Parliament is discussing something, they're going to discuss it, and they're sovereign in their function, and they'll discuss it as long as they want to. And as we've already heard, if more than 50% of the provisions of the Performance Protection Bill are reliant on the Copyright Act, it's extremely difficult to rewrite them at all without first resolving issues in the Copyright Amendment Bill. But even if you were to say we could do that, you'd then have to decide make decisions on those issues, which would then implicate how those issues would be sorted out when they were debated in the Copyright Amendment Bill. So there's no easy way to detangle the two bills. And there's no easy way to send the Performance Protection Bill back for any of, so it would just have to stay in limbo for however long. And remember, we learned again this morning, under Section 79, the president only has a reasonable time in which to sign. So is that reasonable time, is it reasonable to delay the Performance Protection Bill for however many years the Copyright Amendment Bill might be debated further? So that seems to create a real quandary. The only basis in which you could send the whole Performance Protection Bill back at the same time as the Copyright Amendment Bill is a claim around tagging. So, all right, what about the idea that we'd quickly pass some of the portions of the Performance Protection Bill and some of the portions of the Copyright Amendment Bill, but leave the exceptions? So this is problematic on three levels. And the first one is simply constitutional. If we were giving new rights to authors, and by authors in copyright speak, we actually mean artists and musical composers and producers and people who write software. So let's use author for a moment, but it means everyone who produces these creative works. Creators, I think other people were talking about. Well, if we're giving a whole set of new rights, but without balancing those rights with exceptions, then we would run into a constitutional problem, because many of those new rights, without an exception to balance them, would be unconstitutional. Why do I say that? Oh, because many aspects of the current 1978 Copyright Act are unconstitutional. Now, there's degrees to which this is obvious. I've never heard anybody contest that the 1978 Act, our current Act, is unconstitutional to the extent, in the way in which it discriminates against blind people. And if somebody does contest that, well, I'd be delighted to see them in court. I think that's an easy win. But there are others. There's an argument that the current Act, the 1978 Act, is unconstitutional because it doesn't protect freedom of expression appropriately. Because freedom of expression's not as important in our jurisprudence as in the United States jurisprudence, but we could still ask ourselves whether a similar argument prevails in our law as in the United States. In the United States, without fair use, the US Supreme Court has said, copyright would have a constitutional problem. It would struggle to justify itself because it limits freedom of expression. Similarly, we might ask whether in our law, we have protection for freedom of expression. We can't possibly predict all the ways in which we might need to have freedom of expression override copyright in particular circumstances. Now, if we can't predict all of those, that means that the most complete set of fair dealing, the most complete set of narrow exceptions wouldn't survive scrutiny. Because what we need is a flexible standard which can deal with every single conflict, even those that we can't predict right now. Furthermore, we know already the Constitutional Court and the Supreme Court of Appeal have already ruled that learning materials are an essential aspect of the right to education. And the right to education in our law is quite a strong right. And again, we could look at the 1978 Act, and it's at least arguable, maybe not everybody would agree, that that aspects of it are unconstitutional. So we have an act which is potentially open to constitutional attack right now. We have amendments which would seek to cure that unconstitutionality. To abandon those amendments and then give pass some other laws which gave greater rights to authors, would be essentially to pass an unconstitutional amendment, so which would be immediately vulnerable to constitutional attack. So that's the first reason, the constitutional reason. The second reason is that there's, in the legislative process, if you're familiar with it, now not all of it is as familiar with it as the illustrious chairperson of the committee, but even if you have less familiarity, like myself, and you've read all the committee reports, you'll know that the idea is that there's in formulating one section, there's constant thought and trade-off with another section. And so procedurally, it's very difficult to imagine setting aside a whole lot of sections which were conceived in relationship to other sections. That's what happened in the original process. And then there's a lot of textual entanglement where you'd have to track back and make sure that you weren't relying on some portion which are now going to be set aside. Thirdly, we've already heard from Professor Nwauche, Professor Jaszi, globally, copyright has always incorporated some exceptions. The very first copyright statute, the Statute of Anne, which gives copyright to authors, also contains the kind of price controls that, and in fact it gives the power partially to university chancellors, that university chancellors in South Africa would delight to have, and we haven't put that in the Act. But it's always been a balance. Public interest has always been part of copyright legislation. And so the idea that you could separate these two out, again, at international level, Professor Jaszi spoke about the Berne Convention and TRIPS. Both of them acknowledge this role for exceptions as an intrinsic part to copyright law. And then there's another reason. And this reason is that many of the provisions that there's unhappiness about, they're not exceptions. They're provisions giving new rights to artists, to authors. They're provisions giving a royalty right to which cannot be alienated, to visual artists, to authors of literary and musical works. And so, what, are those also problematic? Well, then there's unhappiness, I think, about the limit on the assignment. That's saying that some works can only be assigned for 25 years, literary and musical works. So now, it seems the list is growing ever longer, and I'm not sure what's uncontroversial at this stage. There's unhappiness, although there was a lot of effort to write a very balanced set of sections around anti-circumvention, there's unhappiness around those. So I'm not sure what are these things that have not been made somebody unhappy? And unfortunately, and as somebody who's made submissions to Parliament many times, you don't always get what you want. And I'm unhappy about that. I would prefer that Parliament always listened to me and just did what I said. But apparently in democracy, it doesn't work like that. So I want to return, before we open up this discussion, to the hook that Peter mentioned, the three-step test. But South Africa has other international obligations and other treaties which need to be taken into account in deciding our obligations. And these haven't received as much airtime. And I'm just going to find my list of them. But we have, for instance, Article 19 of the International Convention on Civil and Political Rights. We're required to protect freedom of expression. Well, that simply reinforces our own protection of freedom of expression. We have the right to education, both in the International Covenant on Economic, Social, and Cultural Rights, and in the African Charter. And we're obliged in both of those to education. We have a right to benefit from scientific progress in the International Covenant on Economic, Social, and Cultural Rights. We have an entire treaty on disability that we've signed. Each of those must weigh, when we talk about international obligations of South Africa, each of those must weigh in the balance. And in fact, from South Africa's perspective, they have to weigh in our balance of understanding the three-step test. We don't get to say in our law, and whatever the outcome in the WTO, and however some international trade lawyers might think about it, from the South African perspective, we don't get to say that the human rights obligations are soft obligations and the IP obligations are hard obligations. I don't understand that's the constitutional position in South Africa. We have to weigh them all together. And so when even as we read the three-step test, we have to read it bearing in mind all our international obligations as well as our own fundamental rights.
Okay, so I know Justice Yaqub, you motioned for a question, and if there are any others, I'm just going to take one quick round of questions, and then there's one more, and then we'll be back on track. Yeah, go ahead.
Okay. The way in which a law is ordinarily challenged is when someone complains that his or her right has been infringed in terms of Section 38. It could be a company that complains as well, and they move to court for redress. And that's very important because that's a real case where someone says, my rights have been infringed, and you look at whether that particular right has been infringed in real terms, not in abstract terms, that one is dealing with a real case. That is what normally happens, but the Constitution has made two exceptions to provide for abstract challenges, and that is because, well, three actually. The one was the certification judgment where the court was very reluctant to conduct an audit of the whole Constitution without any real problems. In the same way, the court's going to be very reluctant in the abstract to conduct an audit of a whole law and look at a whole range of challenges to it in the abstract. In the end, it is better to look for a particular case where someone says, my property rights have been offended and therefore I have a problem. And then you look at whether the property rights has been challenged or not. You can't do this in the abstract unless there's a real challenge. And our courts and our law is actually full of that. And that point hasn't been stated for a very long time. There's one difference though, and that is if you say the wrong procedure has been used or there hasn't been proper public consultation, then of course that can be done in the abstract because that affects the whole bill. But you cannot conduct a whole audit. You can't expect the court to conduct a whole audit of legislation to see what right has been infringed by what, whether it's a property right or the right against retrospectivity, what one doesn't know. And one needs to bear that in mind. And it may be that the president ought to be told that he should be careful because the Constitution has provided for these challenges, the presidential reservation right and the right of political party, if they have a particular minimum number to challenge the bill in the abstract. For the rest, ordinarily the Constitution contemplates that it happens when a right has been troubled, and then the person or entity whose right has been troubled goes to a court. And maybe we should tell the president that, to say that is the best way in which ordinarily bills can be challenged, so we don't get caught up in the abstract, in an academic sense, looking and speculating about the potential for the infringement of particular rights in particular circumstances. And I'm afraid I have to go because I have a flight to catch. All right.
Thanks very much for the presentation. My name is Torong Ramela. I'm the Executive Director for Communication Access Organization of South Africa. Mine it is more like a comment. I'm requesting that maybe you say something about one of the key treaties within the WTO, which is called TRIPS, which might be a very big challenge. TRIPS, Trade-Related Intellectual Property Rights, which brought us into troubles in the early mid-90s around the issue of the ARVs, where we were sued as a country because of that obligation in the WTO of TRIPS. And then that matter was swept under the carpet, under, I think, Nelson Mandela's administration. And then we ran the risk of the very same thing because we are the signatory to, together with 140 other countries, to that treaty called TRIPS, Trade-Related Intellectual Property Rights. So I would like the panel to speak about that treaty because it is I think the biggest treaty in terms of that when it comes to many other international obligations. Yeah, thanks. I thought I was going to talk about it in the next panel because I see it there, under the trade law and African growth. But now that one of the panelists mentioned our international obligations. Thank you.
So let me go ahead, and if you don't mind, actually keep that to the next panel, because I know that's going to be what Enyinna is going to talk about right off, is the parallel between the medicines and the copyright issues. And I'll be on the next panel too, and I'm happy to make sure that we attack that if that's okay.
It's okay.
And so then I think, just to keep us completely on schedule, I think we should break now and come to the next panel, and then I think we're very close to making up the time that we lost. So thank you for everyone on this panel.
With respect to the copyright bill, under the threat, the coercive threat of a withdrawal of significant trade benefits under a scheme, or an old scheme called the General System of Preferences, the details of which I think I need not bore you with and probably wouldn't be capable of boring you with even if I were willing. What's important here, sometimes when you're far from home, you feel a little more patriotic than you do when you're close to home. So I feel it as an American lawyer, I need to say that the bad behavior here, and it is bad, it's egregious. It's the complaint that the copyright industries have lodged with the United States Trade Representative's Office in the United States to try to leverage their complaints about the bill is it's a farrago of miscellaneous objections. It's the kitchen, everything and the kitchen sink. It's nitpicking here and some arguably significant policy objections over there, and a gesture, a feint at a constitutional argument over here. It's a mess. But it is, and some of it's completely nonsensical, and other parts of it may make sense, but are pretty offensive. So, all bad. the patriotism I want to exhibit is just to point out that so far the United States government hasn't done anything about this. So far the United States government has registered this document as having been received and has scheduled a public proceeding in which many of us are going to participate to consider whether it should in fact threaten sanctions against South Africa. In other words, it's just the big copyright industries right now that are in effect threatening to threaten South Africa, and it isn't yet the U.S. government, which could just do the right thing, and which we very much hope will do the right thing. In the meantime, however, questions arise, and I can think of three baskets of those questions, and I will name them, and I will let Sean and Jonathan and Nele, if he arrives, sort them out. One is sort of history. Have we been here before? And that goes to trips and medicines and the sorry history of U.S. government efforts to coerce South Africa into privileging the interests of American companies over South African citizens. The second is legality. Assuming, and we hope it won't happen, that the United States government actually did what the copyright industries are hoping they can get it to do, that is, threaten South Africa with the withdrawal of GSP benefits unless the bill is scrapped. Is that legal in terms of the international trading system and all the rules that we've developed over years that go to the preference for multilateralism? And then I guess the last question, and this Jonathan may have a particular take on, is what's going on here? And does someone who is a real Washington policy insider, as he is, have any further insights into what, after all, the IAIPA thinks it's up to, and therefore, in part, what is likely to happen? So with that, I'll just give it to Sean.
Great. So thank you. And I want, so maybe I can pick up, with the question that you raised, since it does fit this panel, which is kind of the history question. What happened the last time, and how is that pattern repeating, right? So in 1999, South Africa amended its health regulations to permit parallel importing of patented drugs from other countries where they were sold more cheaply into South Africa, and was specifically focused on ARVs, although the law was and is, still is on the books, is of general application. And it permits South Africa to purchase, wholesale usually, drugs that are patented both in South Africa and other countries, but they're sold cheaper elsewhere. Interesting kind of lesson from the time where they wanted to import them from was Australia, a country with a much higher GDP per capita. And that gets to the lessons of income inequality, which is that if the income inequality in your country is extreme enough, it can be more profitable to sell just a very tiny number of those items to the very richest in your population and essentially write off the rest of the population. And the reason is because you have to drop prices so low to hit the majority of the population that you end up not making as much, because instead of charging 1,000 per item, maybe you're charging 1 per item, but you're not making 1,000 times as many sales, and therefore you'll actually give up profits by lowering a price to a level that will be profitable in another country with less income inequality. So for that reason, in 1999, the prices in Australia, a richer country per capita, but having much more equal income distribution, were actually lower than the prices being offered by South Africa. So South Africa passed a new law, allowed parallel importation of drugs, and it was sued. It was not actually sued in the WTO. It was sued in your own courts, and the grounds will sound familiar. So the multinational pharmaceutical corporations sued, saying that the allowance of parallel importation was an expropriation of their property under the constitutional protection of property. That was the first step. And the second step was that the US government at the time, it was Bill Clinton that was president, it was Al Gore that was vice president. Al Gore was in charge of a special US South Africa mission, and Al Gore threatened to take away South Africa's GSP benefits. So GSP benefits are special benefits that are granted to developing countries in order to essentially assist their development. And the upshot was that largely because of a mass mobilization, so the Treatment Action Campaign, a global group called Health Gap, created a political mobilization. They were, marching on the courthouse steps. There were protests against Al Gore in his presidential bid. People were holding up signs and elections. It was election season, etc. That political pressure from the U.S. encouraged the Clinton administration to drop their complaint. The political pressure here encouraged the pharmaceutical companies to drop their complaint. And then in the World Trade Organization, a new agreement was put in place called the Doha Agreement on TRIPS and access to medicines. And in that agreement, there were some specific provisions that made clear that the provision on which South Africa was relying, which was Article 6 of TRIPS, which says nothing in this agreement should affect the issue of parallel importation, is what it says it is and leaves states free to adopt parallel importation policies if they want to. And dozens of countries since that decision have passed those kind of laws into their patent laws. And the WTO issue was never litigated. It was essentially conceded. And additionally, an executive order was actually passed by the Clinton administration in 2000, which said no longer can the U.S. government exert pressure on any African nation for adopting an intellectual property flexibility within their law that complies with TRIPS and is meant to promote access to medicines. So there's actually a huge amount of kind of political change. There's a huge amount of political organizing that took to get there. But that kind of put South Africa on the map of leading to clarifications in the world system that made it very clear that those same policies could be taken by other governments and have been since then. And it's an amazing success story. In 1999, if you think back into those days, there was no treatment plan in South Africa. There was an AIDS rate of between 40 and 60% of people between 18 and 50. And none of those people were receiving treatment unless they were paying it for themselves. And now, essentially, all people who need ARVs in South Africa are receiving them, and they're receiving them on prices that are immensely lower. You can now pick up these drugs, the same cocktail that was then being prescribed for $12,000 a year, you can now get from Indian drug suppliers for about $86 a year. That's not the most commonly prescribed drug anymore, but the prices, have gone way down, and treatment has scaled way up. So it's actually a success story. Whether that level of organization will be required in this kind of situation to achieve the same kind of policy goals, we don't know. But there is kind of a phrase that I've heard being used among South African access, which is textbooks are the new medicines. And that's kind of to evoke those same kind of coalitions to stand up for South Africa in a new area where it is moving ahead. I mean, many of the policies are very similar to things that exist in the United States, but some of them are a step beyond. And there be that question of what kind of pressure will come. So with that context, let me just tell you a little bit about, so we have today those two same threats. The publishers are threatening to bring constitutional property rights litigation against the act, and they probably will. So there will probably be a lawsuit that will probably reach your constitutional court if it's not settled on the courthouse steps like that last case was. The U.S. government has not threatened anything, but the International Intellectual Property Alliance, which used to include both pharmaceutical companies and kind of big Hollywood, but is now essentially just big Hollywood. It's essentially it's largely made up of basically the movie industry. But they have filed a complaint with the United States Trade Representative, and they have requested that the U.S. Trade Representative revoke South Africa's GSP benefits, these generalized systems of preferences, these special preferences, trade benefits for developing countries, because of the copyright the copyright amendment bill, which isn't even passed yet. So it's a bit premature in various ways. But let me just tell you a little bit about the law in this area. Oops, if I can figure out how to do it. Because there is law in this area. So there's, is it this one? Okay. So this is the AGOA. So the GSP program here is a special GSP program for Africa. It's called the African Growth and Opportunity Act, and it says that the president may designate any African country for receipt of these special trade benefits. So these are unilateral reductions of U.S. tariffs that would generally apply to other countries, but we lower them for African countries as a special development bonus. So this is not a quid pro quo trade agreement. It's not negotiated with African countries. We unilaterally lower those tariffs. And as long as those countries comply with the eligibility criteria. And so there's several eligibility criteria. It's basically you should have an open market, you should have, you should follow the rule of law. And then there's this one, you should make continual progress toward establishing the elimination of barriers to United States trade and investment, including through, and then the second one there, the protection of intellectual property. So the protection of intellectual property is one of the things that a country must do in order to qualify for AGOA benefits. So that's the first step. That's the U.S. law. That term is very vague. It doesn't say, there's nothing else in the legislation which says what your intellectual property must have. And of course, South Africa protects intellectual property. The question is whether things in the Copyright Amendment Bill that the IAPA might disagree with could be grounds for removing those AGOA benefits. And I've seen multiple trade reports talking about, the U.S. could halt billions of dollars worth of kind of trade benefits. And it's true that those trade benefits are worth billions of dollars. But it's also true, and not stated in any of the articles that I've read in Business Day and elsewhere covering this issue, that there are limits on countries' use of criteria within GSP programs. So the World Trade Organization requires, as a general principle called most favored nation treatment, that all members of the WTO receive the same tariff benefits as any other member. So in order to have a GSP benefits program that's special for developing countries, you have to have an exception to that general most favored nation principle. And that exception exists in a chapter of the WTO itself that's called the WTO GSP Enabling Clause. And that enabling clause regulates the criteria that the US and other countries can use in those programs. And the key terms are that the criteria must be generalized. They can't be negotiated. It's not a quid pro program. It's not a program as if you do this for us, then we'll give you some trade benefits. That's for trade agreements. You have to negotiate those things, and that's a separate part of the WTO. These unilateral programs have to set up generalized, non-reciprocal, and non-discriminatory criteria at the outset that are applied the same to everyone, and everyone that complies with those gets the benefit. And the second term is really the key one here, non-reciprocal. So this isn't a program in which it's a quid pro quo program. It's not if you give us this, we'll give you that. It's supposed to be a development program, a program in which everyone receives that benefit. And the way you decide whether a term is non-reciprocal is through that paragraph 3, whether the criteria itself is designed to respond positively to the development of the developing countries. So the criteria is not supposed to be about benefits to the United States. It's supposed to be about benefits to the developing countries. Now, opening up your markets to U.S. trade is very arguably a benefit to the developing country as well. So there's nothing wrong with that criteria in the abstract, that countries should open themselves up to U.S. trade. Intellectual property, as stated in the TRIPS agreement, is also a development-related aspect of economic policy, right? But the question becomes whether those intellectual property demands go beyond those kind of general non-discriminatory norms and become a quid pro quo, become a demand for a particular benefit from the United States, for the United States. And there's a case on this. So how do you decide whether a criteria is in the interest of the developing country or is an interest of the country granting the benefit such that it should be ruled out as not meeting the non-reciprocal criteria? And here the WTO appellate body, so this one has gone up to the highest level, struck down a particular European GSP program because it had criteria that were not reflected in general international agreements. So what it said is it's not in the powers of the grantor company itself, country itself, to define what those development interests are in a way that simply masks its own interests. So a need, they said, cannot be characterized as one of the specific needs of developing countries merely by an assertion to that effect by the preference granting country. Instead, GSP criteria must be based on objective standards and reflect broad-based recognition of a particular need, such as those set out in the WTO agreement or in multilateral instruments adopted by international organizations. So they should be general, broad-based, essentially reflected in international law. So if you're in labor law, they should be reflecting, for instance, codes of the ILO. And when you're in intellectual property law, those standards should be reflected in the multilateral intellectual property agreements. So that's what ties us into the last discussion. So does the provisions of the bill violate the three-step test? Or does it violate any terms within the TRIPS agreement? Those should essentially be the criteria that are analyzed, not do they have, we have fair use, you have fair use, but when you have fair use, we worry that we'll make less money, so now you can't have fair use. That's not the question. The question is, does fair use violate the international norms in this area? Not do we just not want you to have them, right? And that actually runs into, maybe I don't. Oh. Let's see, I think there's one more on here. There you go. Which runs into the second aspect of the WTO that makes this area more problematic than it was before the WTO for this kind of tit-for-tat use of GSP programs, which is that the main standards in this area are incorporated into the World Trade Organization agreements. So they are in, as the first question was commenting, in the TRIPS agreement. And the WTO agreement specifically state that countries cannot unilaterally adjudicate what does or does not comply with the TRIPS agreement. So that kind of puts this area into an interesting catch-22, that in the GSP enabling clause, you have to base your complaints on broad-based international agreements like TRIPS, but under TRIPS, a country cannot unilaterally adjudicate who is or who is not in compliance with TRIP and nullify or impair any benefit, such as a GSP benefit, on that ground without going through the actual WTO structure. So as I mentioned in the outset of that question, when this went through the channels in the AIDS cases, a complaint actually never was brought to the WTO. And that itself can be a fatal flaw in all of this. So if the United States comes to the opinion that the Copyright Amendment Bill, when it becomes an act, and when the regulations implement it, and when it's actually in effect, which it isn't now, but if at that stage there is an opinion that this law violates TRIPS, then the proper recourse would be to bring to bring this issue to the WTO under TRIPS, not to unilaterally suspend GSP benefits because of it. So for that reason, I would say that the kind of press I've been seeing in South Africa, acting like this is, gonna happen any minute now, and that there's really this massive risk of losing GSP benefits for passage of something in the Copyright Amendment Bill, I would say is severely overstated. It's of course true that any U.S. administration may just look the other way and not care what the WTO agreements say, but in that case, South Africa itself would have recourse, and it would have recourse to the WTO in that situation, and I think for sure that will enter the risk calculation of the United States itself. So with that, I'll kind of pause there, and I think Jonathan might talk a little bit about the substantive arguments that have been raised.
Thank you. So, and Peter also asked, for me to try to take on what is going on, and of course, I have no clue. It's always hard to understand exactly what's going on in Washington. These days, it's even more difficult to understand. So I won't even try to do that. But I will. I'll go through a little bit of exactly digging in a little bit more about where things stand and what are the arguments and so forth. So, as indicated, the International Intellectual Property Alliance filed a petition with the U.S. Trade Representative, and basically saying that, and the petition was that requesting a review of South Africa's eligibility under AGOA for these trade preferences. And the USTR has initiated that review. And so my understanding is that indicates that they have at least made a determination that the IIPA's petition is not frivolous. I mean, it's not clear what exact standard the petition IIPA had to meet to cross that threshold, but in any event that they have decided, USTR has decided that it's not frivolous, so they have initiated this review. There's going to be, they've issued a notice in what we call the Federal Register, which is sort of like the official way notices are put forth, are promulgated. What that means is, in the notice they said that comments are to be submitted to USTR in mid-January. There'll be a hearing in Washington at the end of January, not just about South Africa, but about they're reviewing several other countries, both with AGOA and some other trade provisions. So they'll all be together in a hearing on the January 30th or the 31st. And then there'll be reply comments due at the end of February. And then after that, something happens. Presumably the USTR either suspends South Africa, finds that South Africa is not eligible, or enters into discussions, or somehow something happens. But in any event, nothing can happen until at least the end of February, when the reply comments are due, and then at some point after that there'll be these consultations and discussions, and then something after that happens. Now, the IIPA's petition is on the USTR website. It's available to the public. It is relatively thin, meaning they raise a lot of complaints, but they don't really explain any of the complaints in any detail. And so, for example, They have the several paragraphs about exceptions and limitations, and in particular about fair use, but they don't really explain exactly what it is about fair use that's problematic, other than it's not well thought out, and also that the issue I raised before, saying, well, that there's insufficient precedent on which South Africa can make fair use determinations, or South African courts can make fair use determinations, which of course, as I indicated before, is kind of an absurd argument, given how easy it is in 2019 or 2020 or whatever to be able to find other discussions of fair use and then over time customize them for the South African circumstance. So there is, again, sort of a lot of kind of these very high level and unclear and relatively vague discussions of the exceptions and limitations. I mean, they do flag the education issue, but again, not in any detail, without explaining, okay, exactly what it is that's the problem, what it would take to fix the problem, and so it doesn't give a lot of guidance as exactly what the issue is and how to remedy it. Then, but most, if you look at the petition, there's a lot more discussion about what they call freedom of contract. And a lot of that really gets down to what we've been talking about in the previous panels about the reversion of rights and also the sharing of royalties. And what's really important there, again, as has been discussed, is those are provisions that are designed to protect authors, but against whom? Right? It's not to protect them against users. It's to protect authors against the large media companies. It's against the publishers. And so let's just step back and understand what's going on. What we see, most of the petition deals with the large media companies, as we've discussed. That's who IIPA is, complaining that this bill is too favorable to individual creators. Now, they say other things, that it'll make it hard to, it'll make contracting difficult, and it'll make planning difficult and all that kind of stuff. But that, at the end of the day, is what they're really saying, is that this is too protective of the individual artist. Now, usually, and I'm sure that that's happened here, and certainly that it's happening here when they're talking about the exceptions provisions, but usually the large media companies are hiding behind the individual artists, right? They're always, when they're talking about why more protection is needed, they're always talking about the individual artist. Why? Because the individual artist is far more sympathetic than these large multimedia companies. You're obviously, if you're trying to convince rights holders, you want to have, you want to have people like Sean Harris and how, all his struggles. That is much more sympathetic and much more likely to influence government officials than if Disney comes in and says, oh, we need more protection because our profit margins aren't high enough. Or Reed Elsevier, which is already making a 35 or 45% profit margin off of academic libraries, to say, well, we really want to get it up to 55%. Okay, that's not sympathetic. That's not an effective thing. So they're always pushing forward the plight of the individual author. But let's remember that their main objection at the end of the day here, if you really look very carefully at their petition, their main objection to the Copyright Amendment Bill is that it protects individual authors too much. And then again, we have to sort of say, what is, again, maybe this does get to Peter's point about what is really going on. the media companies have historically, and maybe not quite all the way back to the Statute of Anne, but certainly more recently. I mean, they're basically the whole history of certainly over the last couple of years, a couple of hundred years rather, of copyright law and the development of art is basically the exploitation of the individual artists by publishers and other intermediaries. I would challenge you to find any author who feels that their publisher has done enough for them, right? And that feels that the publisher has really promoted their book well enough. Or we also have this term Hollywood accounting, which you probably have an equivalent here. But it's like whenever you're trying to, I mean, it's amazing. Every single Hollywood film that has ever been made has lost money, right? It doesn't matter how profitable, it has always lost money, because that way they don't have to the extent that there are agreements that require any kind of royalty sharing or shares of profits, no movie has ever made a profit, and so therefore they never have to share any profits. And that's true also with sound recordings. There is not a single, sound recording, not a single hit from. It doesn't matter what label. If you look at the books of every single record label, every single song has lost money. Because again, they attribute all kinds of overhead and all kinds of other expenses, so that again, that's how they are always trying to take advantage of the rights. So, I mean, remember even Taylor Swift, right? I mean, she's had disputes with her record label Prince. I mean, all of these big name performers have had challenges with their labels, and in fact, when it's almost a trope, right? It is a common theme in if you look at almost any movie about a performer, it's always a main theme is how someone is taking it, whether it's the record label or more likely their manager, someone's always taking advantage of them. And it's not just make-believe. I mean, it's true. There is basis that people are always exploiting them. So again, at the end of the day, it's really important to focus on what is the real complaint here, the real concern with the bill is the so-called freedom of contract, which is basically these labels trying and these other publishers trying to preserve their freedom to exploit individual authors. Thanks.
Have time for at least one round of questions. Let's do 3. Jonathan. Push the button.
Right. I think this question takes up from Jonathan's point right there. I guess I'm wondering, so South Africa is sort of small potatoes, I would think. And this is a description of a proceeding that's going to be held in Washington, D.C., in an air-conditioned room, lots of lobbyists, lots of publishers, lots of lawyers, hopefully lots of you guys there, but anyway. So I'm just wondering, is it, I guess, is this in a way a point of principle from the IIPA in the sense of this is like the thin edge of the wedge, or, we just can't let this kind of thing happen? Or, is this like a trade dispute over, and I'll pick the South African example, which is poultry. The other major item goes back and forth between the U.S., but it's also Brazil, is around poultry. There's Ms. Fubb saying yes. That there's real money there, there's real interests, and, that's what it's about. So I guess it's kind of pushing on what is that frivolous, because I assume that from the industry's point of view, they've got to have a significant reason that they are actually bringing this forward. Maybe they can only bring a few of these complaints every year. I don't know. Maybe that's costless to them. So just pushing a little bit on that.
Let's take one more and then we'll turn it back. Please.
Good day, guys. My name is Lulamile Mhapi, part of Recreate. For the past 2 years, I've been teaching video game design in this university. I happen to develop video games. Before I go to a question, I just needed to cement what Ben was speaking about earlier on as an example of fair use. For instance, this year I presented a video game that I created on Winnie Mandela at a conference in Scotland, where we were discussing matters such as using artificial intelligence, using bots, using all the elements of the so-called fourth industrial revolution, but for social change purposes. Now, the reason I'm mentioning this example is that obviously one would have caused a lot of beef around using the Winnie Mandela image or name, etc. But for me, it's an exercise in fair use where you can create new markets or develop new markets, because obviously video games are part of the new economy, digital economy. I prefer to use those terms, you know. So in the digital revolution, we are looking as a country at looking at video games as creating new job opportunities, be for people like Adrian Kelly, who are actors. If you're looking at the animation and voiceovers, if you're looking at motion capture studio building and so on, you know. So it is a whole new economy on its own that is not getting that much ground or getting that much attention in the mainstream, but it is slowly developing in South Africa. And I commend the fact that Prof did mention something about games with regards to fair use earlier on, because even in the academic space, games are not as perceived to be a credible academic study or scientific research study, you know. Now, going into my question is, given that we are in the digital space, we have what we call surveillance economics or surveillance capitalism. I would love to know, in the current legislatures around the world, in particular reference to the EU, the current EU fracas with Facebook and Google and so on, how safe are we as South Africans, especially with regards to privacy laws and so on?
Well, I don't know how safe we are, so I'll leave that to Sean. But responding to Jonathan's point, I think there's a few things going on. One is certainly, and this I indicated before, that the rights holders have sort of complained about every effort to export fair use. And they've often been successful, meaning they've often convinced countries not to include them in their laws. So the fact that it's in this law is troubling to them. And I think the related point is that, of course, you're seen as a leader in Africa, and so there's a recognition that if a certain set of, you know, both whether it's the exceptions or whether it's the all of the provisions that are beneficial to the individual artists, whether if those are adopted in South Africa, it's not only limited to South Africa. There'll be a domino effect, right? It'll happen. It'll spread. The contagion of just like communism will spread throughout the Southeast Asia. That somehow fair use and protection of artists' interests will spread throughout Africa. So I think that's certainly a lot of what's going on. And then I'll just add the other thing, you know, because we talked about the three-step test. There is even though no one knows what the three-step test means, right? Because of there's unlike fair use where there's a lot of precedent, there's virtually, as we've heard, virtually no precedent for the three-step test, and no one really knows what it means. There is a religious quality to it. And for rights holders, this invocation of the three-step test somehow does have this And that's the only way to explain it, is that it does have a religious quality. It's like the Trinity. And so much so that we've talked a little bit about Marrakesh. In Marrakesh, it wasn't enough to repeat the 3-step test once. It's repeated 4 times. So some of us joke that the Marrakesh Treaty has the 12-step test, which of course is an allusion to overcoming alcoholism. But it's like somehow just constantly repeating these 3 steps will, I don't know, it's like an incantation. It will somehow, I don't know, provide greater insight or more protection to someone. I'm not quite sure. But there is this constant need to say, well, that doesn't comply with the 3-step test.
So let me address Lulumile this way, and thank you for all your work on this issue of really really being one of the key mouthpieces, especially in South Africa, of kind of drawing the game industry in to this movement and trying to explain its importance. So I think the broad issue on which you're kind of raising, which is a very legitimate issue, but it must be parsed, is the interest of the technology industry, right? The Googles, the Facebooks of the world. On the one side, their interest in fair use, and on the other side, their interest in access to your personal data. And those 2 things are separate, right? So one of those things is, how do you teach a computer to learn? And the other one is about, how do you teach a computer to sell, right? And you can be interested in the first without being interested in the second. And they exist in 2 different areas of the law, which must both be in the policymaker's mind, but aren't the same. So to teach a computer to learn, like, there's a bunch of different examples, but, translation technology is a great one. So I'm sure you have all had, this experience with this marvelous innovation that's come out in the last decade, where you can open up your phone and you can converse with anybody anywhere in the world, because there are all these translation tools that are based on artificial intelligence and machine learning that can translate one language into another. Well, how do you do that? Well, one of the things that these huge tech companies do in order to do that is they mine everything they can. One of the things they mine is broadcasts. So if you have a captioned broadcast, then you have both a text and an audio, and you can train your computer to listen to the audio and read the texts. And then by learning and doing that over and over and over again, you can teach your translation tool to learn and get better and better and better over time. So does that make a copy? Does that make a copy of that broadcast? Ms. Fubbs is saying no. Yes, it does. It makes a copy. Oh, okay, yeah, it makes a copy. It makes a copy. Is that copy lawful? Well, in the US it is. In South Africa, I'm not sure. Because the question under copyright is not, does it make a copy, is, does it make an exploitation? Does it exploit that work in a way you care about? Because it doesn't upload a copy. A translation tool is not the same thing as Pirate Bay. It's not accessing that video that has captioning and putting a new movie into a website that everybody can download and make a substitutional use, right? So it's not making a substitutional use. It's copying it into a database that it's only used for its own research purposes and spitting out an entirely different product. The translation tool, you have no idea what television shows that translation tool is watching, but it is. It's watching television shows. It's part of the so that's how do you teach a computer to learn? And the answer is you allow it to read copyrighted works and make copies of them, but not copies that have any substitutional effect on the original market. So our program, which believes that the rights of technology and education are often but not always the same, says you should allow those things to happen. The right of researchers to research and the right of education and students to read and the right of technology companies, be they big or small, to make non-consumptive and non-expressive uses of works is good for society. That doesn't mean you have to believe that teaching computers to sell is good to society. So the way you teach computers to sell is you monitor your habits and you download personal data so that it can be targeted back to you. And so I know what websites you go to and I know what you buy and all of that stuff. And you may think that is good or bad, but that doesn't affect your copyright view at all, or at least it shouldn't, you know? So everything that's good for Google is not necessarily bad for you, and everything that's good for Google isn't necessarily good for you either. And so you have to think about those things independently. And so data rights, privacy rights are super important and really have nothing to do with copyright, because that data, that personal data, you don't own that in a copyright sense. It's not expressive. You haven't created an original work. That's just your habits. So it's not copyright that protects you from data surveillance. It's data privacy law. So are you safe? I have no idea. You got to read your data privacy law, which I have not read. But I have read your copyright law, and I would say you're not safe from being prohibited from teaching your computers to learn, which, whether you're in the game sector or other parts of the technology sector, may be really important to building your own technology companies and actually competing, whether it's with the big guys or the small guys.
And I might just add one thing in response to that fascinating question. I agree with Sean that having a robust fair use provision in copyright law helps in a lot of ways, and it doesn't hurt from the standpoint of privacy protection. It is, in a sense, it runs parallel but doesn't intersect. However, there is one relationship, and it is that fair use enables us to know more about how the privacy rights of citizens are in fact abused. Fair use allows us being readers who in turn depend on investigative journalists and others, to have access to the widest possible range of corporate documentation about practice and malpractice in the data sector, all of which is proprietary information, all of which is covered by corporate copyrights. The reason we can read those things, the reason we can share them, the reason we can critique them is because we have fair use or fair dealing or some other expressive exception in copyright law that allows us to speak about matters of importance, such as privacy. Ms. Fox.
If I may, first of all, what you were referring to, Professor Flynn, is covered constitutionally in South Africa, which makes access to knowledge one of the priorities, and I did make a reference to that earlier. And of course, the other issue, I wasn't able to conclude my input, but would have mentioned the importance of artificial intelligence, etc. I called it AI. But one of the things that is interesting is TRIPS. At one point, I also seem to be a disciple of TRIPS, but then I'm much older than most people. Now, I soon, and thank heavens, one is able to change one's mind with new information and so on. But it's become apparent to me in the last 20, 15 years and so on, that TRIPS is not necessarily supportive of developing countries, because it was, in fact, its whole architecture was for the 20th century and driven by countries that were developed for the most part. So it doesn't really suit the developing countries. And the other problem on that is with regard to TRIPS, and it's one of the reasons why we have certain reservations about certain international treaties and so on, because we found ourselves, I don't know, very much like some new presidents just signing everything, and then suddenly realized what we'd signed. So now we're far more cautious on what we are prepared to sign in this regard. We don't have 3-step or 4-step issues, so, it's just more like a waltz, a 2-step issue. But if I can just, the other thing you did, Professor Flynn, make a reference to the pharmaceutical issues and so on. And again, one must say, that too is a TRIPS issue. And that's, simply emphasized and underlined my decision that it does not suit the developing countries at all. And one of the things it actually did, it impacted negatively on the development of new chemical drugs or whatever. Perhaps there wasn't an incentive. It disincentivized them because of a virtual monopoly due to pricing, etc. So one is rather pleased we were able to overcome that. Now the whole thing is around books and education. And anyone who writes, of course, realizes that some authors do depend on their writing for a living. So it needs to be balanced, that right, with the costs to the user. And is there any way of ensuring the user can still use it? Well, as I said earlier this morning, whether we like it or not, Google, Wikipedia, and I don't know what else, Instagrams, Facebook, the whole catastrophe is here. And we better like it because it is not going to go away. We better learn to cope with it and to use it, which is why I'm now digitizing my poetry and writing. For that very reason, because I learned from my grandchildren. Look, and I always remind them what I was told by a German professor. When things just break down, and they will and they can sometimes, if you don't know how to read, the robots will know. So you better know how to read so you can read the manual to get these satellites up and running and that kind of thing. And again, I do hold a different view. I don't believe that there will be that the new industrial revolution and so on cannot become labor absorbing. What I do believe it requires, and it demands, that's what I spoke about, a learner economy. We are going to have to reskill, or, and as if we are older or if we are younger, we're going to have to push the government to transform the curriculum. Thank you.
Very insightful and inspiring indeed. And yeah, we've learned so much. I just want to, just take you up on the issue of data mining, Sean. Data mining, the 4IR stuff. Are we maybe, are we caught up in a subversion of what we should be focusing on? We're currently focusing on copyright, but actually the money is being made from advertising. They know who you are, how old you are, what you eat, what you wear, and all of that. So, and obviously, I remember, this is one of my biggest cry in terms of the bill. But I'm also told, no, that one belongs. The issue of safe harbor, where ISPs hide behind safe harbor, yet use copyrighted work and make money off advertising. Belongs in the ECT, the Electronic Transmission Act of South Africa, which still needs to be amended. We still have to deal with that. So are we moving with the necessary speed? Because of, I think, with the development of digital age, these guys are, the digital age is running faster than us, and then we caught napping. And whilst we're talking copyright, then people are subverting the whole thing. They're making money off the back of advertising. And they're not sharing with us, Google, YouTube, and all of them. They don't declare those profits enough. If they give you 5 zeros before a digit. What would you say to that? And lastly, in closing, the current bill is unconstitutional for many reasons. And the current amendment, the 1978, the old one, is unconstitutional in many ways. The current amended bill addresses those gaps. So are we able to take the president to task and say, we're going to take you to the Constitutional Court because of you making us sit with the old bill that is problematic? I don't know.
Thank you. My name is Juan Camarano. I'm the Trade and Investment Officer at the U.S. Embassy. So I'm here in listening mode only, and I'm not here to argue on the merits of the bill or any of that, but I did want to make a couple of observations quickly. I think one, just to point out, because it's so undermentioned, but it should give pride to my fellow countrymen there, the example used on the ARVs, the U.S. government, USAID, actually had a large role in negotiating the price of those ARVs down to the price that they are. And in fact, through the President's Emergency Response for AIDS Relief, or PEPFAR, we've put in over $5 billion into South Africa alone to save people from HIV. This year we'll be contributing $750 million in South Africa to help fight HIV. So in the way that that folks will look at the United States and say, you're always promoting the private sector, it's important to know that we go beyond that. I think in many cases, the things that we do are really fighting for a level playing field for our companies. It's about market access and ensuring that our companies have the same type of market access. So taken within that light, you can understand some of our motivation behind the GSP review, which I will say is a review. There's been no decision taken. It's a protracted process. It's not singling out South Africa like it was pointed out. There are a number of countries that have gone under review. GSP benefits have been removed from some countries like India and Turkey, and if you want to look into those specific cases, which is to say that the review shouldn't be taken lightly, and the South African government, which is working very closely with us on the review process. So we know that there's a commitment from South Africa as well to look into this. The criteria for the review have not been set. So at this point, we cannot say what the United States will be asking for South Africa to show or to prove. I can say I've been involved in a number of conversations, not only with the U.S. government, but also with stakeholders here, and none of them seem to push back on the idea of fair use as long as it is introduced in a way that will benefit South Africa and not potentially harm it. So in sort of my last point, I will say one of the things that I have heard, and I do want to just make a note of it for those in the room, there's a lot of demonization of the private sector. And I think it's easy to sort of point your finger at, entities which are basically there to create profit for their shareholders, for their owners. But they are also the employers, right? And so coming back to this idea of balance, I really do believe that it is the right approach. How do we find a balance so that the private sector can still thrive? Let's not make them out to be the enemies. Let's figure out a way where we can enable them to create more jobs and to bring more prosperity to South Africa. And I think that that's something that, we're really committed to in the U.S. government in terms of helping investors come into the country, helping companies bring in foreign direct investment, and helping take South African products out to the United States through programs like AGOA and GSP. So thanks for your time.
I just wanted to say that this is on the U.S. Embassy website in South Africa. It's an interview between the new ambassador, Lana Marks, and a newspaper of ours, Daily Maverick. And when asked about, sorry, I've got a croaky voice. When asked about the threats of trade sanctions, these are her remarks. No, it's not a danger at all, Marx said about the apparent threat of South Africa losing AGOA benefits. I just don't see that happening with the current robust relationship working so closely together. All our agencies working together in such a positive way, I just don't see that being a problem at all. And that's from Lana Marx.
So I think, I mean, just to agree with Juan on several points. I mean, first of all, the U.S. absolutely massively changed and is one of the largest purchasers of AIDS drugs in the world, and they're largely generic AIDS drugs. I mean, so it's they're not using that program, you know, just to buy patented drugs, for instance. It really was a policy change, but that policy changed, and that's been in Democratic and Republican administrations. George Bush was one of the largest contributors to, you know, so this isn't just a party political issue, and I definitely I agree that the United States is being a good actor in that now, and I have every hope and faith that they'll be a good actor in this case as well. They have not announced that they agree. It's just a petition, and it's a petition actually from a relatively small group of U.S. businesses. It's not all U.S. businesses. Actually, South Africa has received letters from other U.S. businesses supporting the bill. So the U.S. is not on one side or the other on this issue, and in fact, you see us, all of us are from the United States and are here supporting the bill. So it shouldn't be seen as just one side. On the private sector point, I mean, I think that's right as well. And I also don't want to say that the IAPA or the movie companies have no legitimate points at all, right? And I think the big question is, can these issues, where they're legitimate, can they be addressed in regulations that kind of address the needs of everybody? So, for instance, U.S. filmmakers have the same interests as South African filmmakers. So the fact that there are U.S. filmmakers making that noise, the same noise is being made by South African filmmakers. And, you know, I hear, for instance, how are we going to deal with these reversion rights when we want to sell products permanently? And so what do we do when the performers get their rights reverted in 25 years and the writer gets their rights reverted and all of this happens? How do we create a product that we can sell on the market and actually sell, right? And I think that's a legitimate issue. And I don't know, but I think it might be able to be addressed in the regulations, you know? So I you know, as Adrian said earlier, I think there's possibly, and I don't have the real answers, I'm just kind of trying to think this through, and a lot of us have been talking about that, but, you know, could the regulations say, you know, here's where you could actually say, sure, the rights are going to revert, but they're automatically going to be there, you know, unless, you know, and actually draw out the categories for how that could work. Or, you know, having a no holdup provision. You know, the object of this is to make sure people have the opportunity to continue getting paid, you know, and redo that contract as necessary, which isn't that big of a deal. But taking away that fear, which I've heard expressed, and it seems to me a legitimate fear that, like, well, what if somebody comes and now they're going to say some extra in the back doesn't get their royalty payment and now you're going to cease. I don't think that's what the law requires, but I do think it's a legitimate interest, and certainly the law doesn't specifically say that's not going to happen. So that seems to me, and that's the question from the last panel is, and I think this is almost the main way forward. I think, you know, Denise, you mentioned maybe we should end on a little bit. I would leave this as the way forward, that South Africans should think of and ask us for help where we can. But how do you deal with all the legitimate complaints in regulation if you can? And are there any that you cannot? You know, are there any issues that need clarification that cannot be clarified under regulation because of something in South Africa law? And I haven't heard one of those issues yet, but that's not to say we haven't gone through all the issues. But so I get the sense sometimes that people think that right now it's either the president sends it back or the president signs it, and that's it. And the truth is there's a whole nother stage of this process, because the bill, as I read it, doesn't go into effect on the date of signature. It goes into effect on the date of promulgation of the regulations, which means if people have legitimate issues that are basically about clarifying and defining rather than doing something different. So you can't take out the fair use clause that way. But I agree with you, the complaints I've heard are not actually that you have or don't have a fair use clause. You know, they're worried about, well, this seems a little vague or whatever, but all those things can be defined. So I think that's the big next question that I would be communicating to the president, but also to other stakeholders, that this is really the start of the process, not the end of it, that there's a whole nother process. And what that, you know, and I don't know if the other agencies are here, but I'd be asking the agencies, you know, what's that process going to look like? Are you going to have a public process? Are you going to bring everybody together? Like, you know, is this going to be a new moment to kind of, what are we calling this? Break the impasse and bring people together to talk about the real problems and how to go through with it? Because I know people feel like they're in camps right now, and ultimately the camps have to come together. This was literally, and you know, I think Denise said this is opening. This meeting, originally when I was invited here, was supposed to be both sides together, talking about what those issues were, so that we could legitimately, and we actually came here to do that, to talk about, well, where are the legitimate issues and how can we get over them, and can we address them in regulation or not? And so I'm kind of sorry that this ended up being a little bit of a one-sided conversation. We've tried to represent the other side and try to bring in where we think some of these legitimate issues are. I hope that message came across clear, because I think there are legitimate issues that need to be solved, and you know, we as Americans can't necessarily solve them, but we have a lot of experience with copyright, so we're happy to be consulted. And then, I mean, let me invite up Denise, but before I do, let me just thank Denise, because wow, this meeting had hundreds of people in it, and it's all her. And she's one of these incredibly selfless individuals that plans an entire meeting and then doesn't put herself on the agenda. Even though she has the most to say. And so just if there's any doubt, I mean, the reason the bill includes to what I think is all this good stuff is because of Denise's work, and she's been doing this work for literally 20 years. And the library exceptions and the education exceptions and the fair use clause and all the stuff that honestly I think is really interesting and innovative pretty much came from her sharing information with the government, sharing information with each other, bringing people like us into the mix, making sure that a large kind of coalition of people, and doing her damn best in this meeting to really create that vision that we would all kind of be together talking to each other. And I'm sorry it didn't come out, but it wasn't lack for your trying, you know. So thank you for all you've done on this thing. When this comes through, the party's for you, you know. It really should be.